Greetings, YouTubers. Welcome to part 2 of our McCain-is-through refuse to take our Elena Kagan challenge. Ilya Shapiro of Cato writes, the Supreme Court upheld the First Amendment by declining to add a category of unprotected speech. This was the U.S. versus Stevens case. This was not, after all, a case about the human sacrifice channel or Michael Vick's greatest dogfights. Indeed, cruelty to animals should be and is punished everywhere in the country. Instead, at issue here was a broadly drawn depiction of animal cruelty statute that could have ensnared Spanish tourism brochures or hunting instructional videos. More fundamentally, the court rightly rejected the government's proposed weighing of the value of speech against its social cost. Where have we heard that before? That's simply not the way Americans view, or should view, the First Amendment. The case is also notable because a solid majority of the court rejected the speech balancing test defended by Solicitor General Kagan, often mentioned as being on the short list of candidates to succeed retiring Justice Stevens. This, of course, was back in April when Shapiro wrote this. Chief Justice Roberts' opinion, joined by all the panel's libtard justices, went so far to call that argument by Kagan startling and dangerous. End quote. In her Supreme Court oral arguments in the corporate speech case of Citizens United versus FEC, Miss Kagan, hedged on whether government could ban corporate-funded political books, but she did say that a pamphlet would be different. A pamphlet is pretty classic electioneering and thus subject to campaign restrictions. Censorship. In the government's brief in a case called United States versus Stevens, Miss Kagan elaborated, whether a given category of speech enjoys the First Amendment protection depends upon a categorical balancing of the value of the speech against its societal costs. Who is in charge of this balancing? Kagan. Giving the government that kind of power would be a terrible idea. I don't like the KKK or the Black Panthers and other organizations, but giving the government that power would end up pretty soon. A lot of people are going to be shut up. So that's a dangerous precedent that Kagan's flirting with there. Dangerous idea. In a 1996 University of Chicago Law School Journal article titled Private Speech, Public Purpose, the Role of Government Motive in First Amendment Doctrine. Government motive in First Amendment Doctrine, which gets raved from left-leaning legal academics. Kagan contended that the application of First Amendment law is best understood and most readily explained as a kind of motive hunting. If the motive is compelling enough, in other words, the government can regulate speech in the name of the public good. Yep, in the name of the fairness doctrine, anyone? Internet neutrality, anyone? Hello? Justice Anthony Kennedy wrote in the majority opinion, this is FEC versus Citizens United again, we're back to, that Kagan was defending a law that represents an illegitimate attempt to use censorship to control thought. He declared, this is unlawful. The First Amendment confirms the freedom to think for ourselves. Kagan wants to shut you up. If the government doesn't like you, she wants the government to be able to shut you up. Like I said, fairness doctrine, internet neutrality, that's what they're setting it up for. Nat Hentoff wrote a scathing review of Kagan, saying, quote, rejecting Kagan's argument, Chief Justice Roberts noted that the government had taken a position, as argued by Kagan, that embraced a theory of the First Amendment that would allow censorship not only of television and radio broadcasts, but of pamphlets. He realized that it would go further than she intended, of course. Going back to Hentoff's quote, I know that a Solicitor General is required to argue the legal positions of the administration that hired her, but to this extent, I'd also like to know how Supreme Court Justice Kagan would react to those in the Obama administration who urge more media diversity. Their poorly disguised attempt to return to the fairness doctrine, whereby the FCC could revoke the license of a radio or TV station that was not being fair in its distribution of political views. End quote. Our last piece of business pertains to a question from Michael Cannon to Kagan, and this might be the big one. This might be the 800-pound gorilla in the room. Quote, Senate Judiciary Committee members should be sure to ask Kagan, during her upcoming confirmation hearings whether she or her office played any part in crafting Obamacare or the administration's defense to the lawsuits challenging that law. If Kagan helped to craft either, that would present a conflict of interest. When those lawsuits reach the Supreme Court, she would be sitting in judgment over a case in which she had already taken sides. Though the Solicitor General deals with appellate matters, it is certainly possible that Kagan was consulted during the drafting or the law or the administration's legal strategy for defending it. It is not certain, but it is certainly possible that the officer of the Solicitor General was consulted on the government's response to lawsuits that would likely reach the Supreme Court. If Kagan played a role in drafting Obamacare or formulating the administration's legal defense, and is confirmed by the Senate, propriety would dictate that she recuse herself from any challenges to that law that reached the High Court. Supporters and opponents alike should be interested to know whether the court will judge Obamacare with 9 justices on the bench or 8. So that's a big one there. In review, folks, Kagan has a an insane judicial philosophy that the little guy should win even if he's in the wrong. Justice is supposed to be blind to color, income, social status, etc. She obviously will not do that. She will have judicial empathy towards the little guy, even if the little guy should lose. Her arguments in U.S. versus Stevens and FEC versus Citizens United demonstrate that she does in fact favor the government censoring certain speech that it doesn't like, that it doesn't deem valuable, which means your speech could get shut up. And then the healthcare thing, of course. Cannon brought up a good question there. I'd say in review, Elena Kagan is not SCOTUS material. She should not be on the Supreme Court. So here's what you need to do if you haven't. Contact your senators, and you can use those talking points. I'll have those links, of course, underneath the video as usual. mccainisthrough rarely does that. A lot of times she puts nothing on there or sends you off to some, oh, go visit this guy's channel over here. Yeah, he's got something. Use those talking points. Tell your senators to vote against confirmation of Elena Kagan to the Supreme Court of these United States on the grounds that she does not understand the First Amendment and wants to squelch free speech. Have a nice day. And McCain is through. You can go ahead and put up a video now after I've done this, pretending not to know that this was up or I issued the challenge, and you can avoid anything I brought up. Just go cut and paste something from Keith Olbermann. Have a nice day, and don't thank me now.